I take that point, and the government concedes that a decision not to list something is unreviewable.
Yes.
But says that Free Enterprise Fund blessed that arrangement already. What are your thoughts?
The difference in Free Enterprise Fund was the SEC had all sorts of supervisory authority over the PCAOB, the Public Company Accounting Oversight Board, that is not present here. The SEC could review and alter any rulemaking done by the board. The SEC could review and overrule any sanction that was being imposed by the board.
But what about any non-action by the board?
Well, if you look at page 504 of the Court's opinion in Free Enterprise Fund, it lists all the ways in which the SEC had these oversight authorities. And this is not, with all respect, Your Honor, this is not a situation of non-action. When the task force decides to issue a C, D, or I rating rather than an A or B rating, that is action. It's not inaction. If the task force decides to withdraw an A or B rating that it previously conferred, that is also action and rather than inaction. So the government's brief tries to rely on the act-omission distinction. It just doesn't hold up here. There will be situations in which the task force can take affirmative actions that cause a certain type of preventive care not to receive the A or B rating, and the government concedes that's unreviewable. So that means they're still principal officers. But there's a second problem as well. Even if this Court were to think that task force members become inferior officers under the government's interpretation of the statute, these are still unconstitutionally appointed because Congress has not vested the Secretary of Health and Human Service with the authority to appoint the task force. And the Court of Appeals did not reach this question, as Justice Gorsuch noted during the questioning of Mr. Bupont. But the Court would have to conclude that there was vesting of this authority in the Secretary before it can say that they're constitutionally
So are you saying we
now.
should remand to the Fifth Circuit to let them address that for the first time?
The Court should not remand unless it disagrees with our principal officer argument, or if the Court wants to impose the severance remedy suggested by the government.
So if we disagreed with your principal officer argument, you would say that you disagree with our principal officer argument, but then remand to the Fifth Circuit to give them a crack at the appointment?
I think there would have to be a remand in that situation, Justice Barrett, unless the Court thought the issue was so open and shut.
Why do you